you'll give me the signal first. Okay. Ready? Great. Good afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and I'm delighted to welcome you today to today's virtual happy hour in honor of the repeal of the 18th Amendment 90 years ago. Nancy Maveety is a professor of political science at Tulane University in New Orleans, Louisiana, where she teaches courses in constitutional law, judicial decision-making, and her latest special topics class, Booze, Drugs, and the Courts. Who wouldn't want to take that course? Sign me up. She is the author of Glass and Gavel, the U.S. Supreme Court and Alcohol, published in 2019, as well as many scholarly works on the U.S. Supreme Court and American judicial politics. Most recently, Picking Judges, a study of federal judicial selection politics styled as a presidential briefing book. Nancy also wrote an academic satire novel set in the Crescent City, The Stagnant Pool, Scholars Below Sea Level. Nancy is an amateur cocktail enthusiast and has regularly attended New Orleans' annual Tales of the Cocktail meeting since its inception over a decade ago. She supplements her collection of study of interesting and unusual liquors and wines with regular international travel, such as to Barcelona, to participate in vermouth drinking culture of Catalonia. And she's also a board member of the New Orleans Citizen Diplomacy Council, a nonprofit organization that helps to facilitate the hospitality and exchange of international visitors to the city. Nancy has been a Fulbright Scholar twice, first to Estonia and more recently to China. We're going to be mixing our cocktails and mocktails and chatting about the court and alcohol and taking questions from the audience. Please share your questions in the Q&A box on your Zoom window. Professor Maveety, thank you very much for joining us this evening. It's almost cocktail hour on the East Coast, not quite in New Orleans yet, but well, in New Orleans it may be cocktail hour, whatever you want.
Thank you. Thank you for having me. I'm delighted to be here.
Let's begin with the cocktail you might be making. I'm going to make an Arnold Palmer. I'm told yours is a variant on the McKinley Delight, which has a connection to Melville Fuller, as I understand it. And meanwhile, I'm going to channel the golfers on the court with an Arnold Palmer. That sounds a little weak, but that's what I'm doing.
Well, of course, I'm not actually mixing right now as I'm sitting in the office at 4 o'clock, but I'm thinking about McKinley's Delight, which is one of my favorites from my research in looking at the Chief Justices, their eras, and what were popular cocktails and behaviors with recreational use of alcohol at the time. So McKinley's Delight is, as you mentioned, it's a variant on what was already a very popular cocktail in the late 19th century. That was the Manhattan, which I think most of us are familiar with.
Mm-hmm.
The McKinley's Delight was invented in St. Louis by a bartender who was working as part of the Republican convention that was meeting in the city, and named the cocktail after, of course, that year's party candidate, William McKinley. And what makes it an interesting variant, an unusual variant on the Manhattan, is that it adds a couple of accent ingredients that show that at the time, certain luxury liquors were coming into use and were very popular in advanced cocktailing, which is very much typical of the Fuller period. And so those ingredients were absinthe and also a cherry brandy type item known as cherry hearing. And so to make the McKinley's Delight, one would make one's preferred Manhattan mix using rye whiskey, which is, of course, the traditional whiskey that was used. It's a little bit drier. Some people prefer bourbon with their Manhattans, and then, of course, sweet vermouth. And then add a dash of each of these other ingredients. Stir, never shake with clear ingredients, always stir, and then served straight up with a cherry garnish. Certainly the traditional way to have it. As I describe it, boy, it sounds good. I'll
It
hope
does.
to have one soon. But I selected it because of its political reference, and the connection to Melville Fuller is this. He was, of course, a Democrat and appointed by a Democrat, but by the time of the McKinley contest, temperance and prohibition is already becoming a very formidable public policy issue. And the Democratic Party's candidate was William Jennings Bryan, who was a noted abstainer and a rather harsh customer in a lot of public policy matters. Fuller did not agree with him and probably in his heart supported both William McKinley and the idea of having a McKinley's Delight. So that was my reason for selecting it. It's a great cocktail and it has a great story too.
It does have a great story. How did well, let's talk about how your interest in the whole topic, how that arose, and then I'd like to get into the history of how the country came to repeal the 18th Amendment. Let's talk about the 18th Amendment and its repeal. But first, your interest in the topic, and did your presence in New Orleans have anything to do with that? Did it influence you? You picked a good city.
Maybe so. And it is a city that is the origin of many, many famous cocktails. And it has, quite an established cocktail culture. I would say, though, the story of the origin for this book is that it unites two interests of mine. One is, of course, scholarship on the Supreme Court and the development of constitutional law and the politics of the court. And the other is, as you mentioned, my interest in cocktail history and in the social history of alcohol in American life and American politics. And so this is kind of my fun book among my, although my novel was fun too, but this is kind of my fun popular history / let's make constitutional law and the study of constitutional law a little bit different by looking at it through the lens of alcohol and alcohol in American public life. So that's where it comes out of. And I had tremendous fun writing the book and doing the research for it as well.
I imagine your classes are very well subscribed or popular.
Oh, well, sometimes, yeah. And the one you mentioned certainly was a popular class, particularly because we got into discussions somewhat parallel to the regulation and enjoyment of alcohol, discussions about, for example, recreational marijuana and direction that is taking constitutionally. And so that's, of course, of great interest to my students for various reasons.
Sure. Some of them academic.
Some of them academic, indeed.
So how did the country come to repeal? Let's talk about the history of the 18th Amendment and how the country came to repeal the 18th Amendment. It's the only amendment in the Constitution to be repealed in our history.
Yes, that's right. Well, there's actually quite a long history leading up to the Prohibition Amendment, as it's also called. Supreme Court decisions have in fact acknowledged that there's a long legacy of both enjoying alcohol as part of American culture, but also regulating it and disapproving of it or disapproving of its overuse. And so, there's a current of temperance feeling that really begins early in the 19th century that begins to shape conversations about whether barroom culture is having a negative effect on Republican values and the practice of democracy. And so there is a quite long conversation that ensues at the state level about whether alcohol should be limited. And usually the conversation at that time is about what was called strong drink or liquor, intoxicating beverages of a stronger kind than beer or wine. And so the temperance movement, interestingly, originally only applied to strong drink, didn't apply to more moderate versions of beverage alcohol. But as we move into the later decades of the 19th century and then the early decades of the 20th, we see the Prohibition movement unite with some other political currents that give it a stronger emphasis. The progressive movement, which is about certain kinds of social reform, pick up on the value of regulating alcohol and restricting its use by certain persons, certain classes of persons often. And it's also World War I that profoundly shapes the idea that ultimately it is the national government that may take action to take steps to delimit the use and availability or the transit and the sale of beverage alcohol. And that's what brings us finally to the 18th Amendment. It's a culmination of many currents that are long-standing, that are enduring throughout the 19th century, really.
Was it regionally based or generated? Do you see differences in attitudes, or what was driving this at the time, different in different regions? I just wonder, in my own background, having family from Kentucky for centuries, what the attitudes were there. I mean, you had certainly religious interests kind of on the one side, but then it was very much even part of a business culture in that region as well. So how did it reminds me of an interesting story I'll share with you in a moment about the conflict between the two, that is the religion and
Yes, indeed. Yes, indeed. And so that's why I almost hesitate to say that it is regionally focused.
yeah.
There are definitely, strong elements of temperance sentiment that coincides with certain religious affinities. Some would locate that, in parts of the American South or in parts of the Midwest. And I think a lot of it had to do with the demographics of different cultures. And so, in one way, temperance and prohibition was about a conflict between certain political elites and the waves of immigrants who came from countries that perhaps enjoyed a different use of alcohol, Catholic countries, Italians, Poles, where perhaps beer drinking was an important part of culture as well. So in some ways, the conversation about regulating alcohol was also a conversation about regulating people and about restricting who might have political access, because bar rooms were often sites of political organizing as well. And
Right.
so I think there's a lot more heterogeneity to the forces that are shaping temperance and prohibition. And we cannot leave out the importance of the Anti-Saloon League, which is almost, one could think of it as the first special interest group that mobilizes and organizes what are different and disparate strands of the prohibition movement into a solidified national current. So that's kind of the background regionally. I mean, I think there's more we could say, but it's not as simple as this region was dry, this region was wet.
Yeah. Yeah. Well, and the dynamics of dry and wet counties, even if I'll go back to Kentucky as an example, but that was driven in some part by the dry counties. The moonshiners wanted to keep the counties dry. That was their business. So it didn't even sort out regionally that way.
Yeah, and that becomes a really interesting dynamic once prohibition goes into legal effect. Once it goes into legal effect in uh, January 1920, with the passage of the Volstead Act, there comes to be a great problem that arises that prohibition, in a way, creates or helps create, and that's organized crime around the illicit uh, distribution and also manufacture of alcohol
Yeah.
at a large scale. And so a lot of changes occur, massive changes in what the federal government is responsible for, what the expanses of its powers become, and all this is due to what the 18th Amendment unleashes in some way.
Mhm. Was there any correlation at the time between prohibiting gambling and prohibiting alcohol?
Yes, I mean, there are definitely cases in the docket from the 19th century where there was a move to regulate vice, or to think about
Yeah,
vice as something
yeah,
that was an appropriate subject of state police powers. Now,
yeah.
that's what the discussion, that's the turn the discussion took. And so, yeah, I think some of those efforts were also around, regulating other illicit behaviors and
Hmm.
thinking about using law for moral benefit or producing certain, moral consequences.
The story I was reminded of as we were discussing this is I remember when I was I was a godfather to a nephew of mine, my cousin's son, and the christening was in an Episcopalian church in Lexington, Kentucky. And after it was over, I walked to the back. The church is a beautiful
Mm.
old stone church with beautiful wood carvings in it, and there was a plaque in the back of the church, and it said, "This church is dedicated to the glory of God and the horse." And I went up to the Episcopalian priest afterwards. I said, what is that about?" And he said, "Well, in the late 1800s, maybe early 1900s, there was uh, something on the ballot that would have outlawed gambling in Fayette County, Lexington, Kentucky. And the Episcopalian priest there was a big fan of horse racing and and going to the races, and he helped defeat the bill that would have outlawed gambling in Lexington, Kentucky, and saved the horse racing industry in that region of Kentucky. So they built this Episcopalian priest a church, and that's why it's dedicated to the glory of God and the horse.
Oh,
So
no.
I wondered if there was any correlation between the sort of the morality movements that attach to alcohol prohibition as well.
Mm-hmm, mm-hmm.
Well,
Lotteries were often a target.
lotteries.
Yeah,
Yeah,
lottery. Yeah.
yeah. Well, how did the country come to repeal the 18th Amendment?
Well, that's uh that's another kind of long and somewhat not quite as long as getting to prohibition. But I think there are various elements to suggest that there were both popular as well as political and institutional resistances. And so another scholar who writes on the Prohibition era talks about what he calls the popular constitutionalism of the speakeasy. So there was a certain amount of defiance of the law during Prohibition, and many legal scholars and political thinkers worried that this was contributing to a general attitude of lawlessness or disrespect for the law. But I think united with some of this popular discontent was also a steady stream of criticism of the 18th Amendment and the kind of regulatory scheme it put into place, the expansion of national power that it articulated, and the odd kind of concurrent regulation of alcohol that it described. And so there were forces that defended both an idea of limited constitutionalism and also an idea of just state prerogatives, who remained resolutely opposed to the 18th Amendment and continued to work against it. And I think what probably dealt it its death knell were some of the massive economic challenges presented by the Depression era, and the need to resuscitate industry and to use whatever might be possible, to stimulate business, including breweries. And so many threads come together to undo what had been certainly popular in some circles and certainly effective in the sense of diminishing overall drinking, but inspired so many other unintended consequences that it was really not controversial at all when the amendment was repealed.
And by what was do you recall the vote or what? I mean, I know there were polls at the time, but was it overwhelmingly?
Yes, I would say so. Although what was interesting was that the 21st Amendment, which is of course the repeal amendment,
Yeah.
preserved quite a lot of state authority to restrict and even prohibit alcohol locally. And so I think what the 21st Amendment did was balance some interests to say that, well, what we all can agree on is that this national scheme has not been the correct direction, whether failure is the word you want to use or not. But the 21st Amendment allowed a carve out that maintained for states and for dry culture areas of states the option of having their own local solution. And that is pretty much where we are with the way alcohol is regulated. So I think that kind of framing was what made it possible to move so easily, although it certainly wasn't effortless for the Supreme Court. Their docket became chock full of all kinds of cases about how the post-Prohibition period should function.
Are there many dry counties left in the United States?
Well, I don't have an actual count at
Yeah.
the ready, but there certainly are dry counties that exist, and they aren't only in the Deep South, where most people would probably associate them as being. There's a beach community in New Jersey, for example, that is a dry town. And really what they're trying to prevent their town from becoming is a destination for by the drink commerce, in other words, people coming to bars. It's not that you can't have alcohol and drink it privately. It's just they're trying to delineate the sort of community they want to be, the sort of family beach community they want to be. So we don't think of dry counties as happening in the Northeast, but I think there are various reasons communities might describe themselves or want to describe themselves as dry. It's just that dry means something rather different now when you're surrounded by jurisdictions where alcohol is legal, available, and can easily be transited into where you are.
In a community like that, the one you've described in New Jersey, could you bring your own bottle into an establishment and they would allow you to pour it? I remember around Kitty Hawk, North Carolina, that used to be that way. This was 40 years ago, but I don't know what it is today.
Yeah, I mean, I think that would be a local option to decide, presumably. But even during Prohibition itself, consumption of alcohol was not illegal or unconstitutional. It was everything else about it, though.
It kind of went up.
Making it, selling it, and so there was an attempt to, I suppose, preserve some element of individual liberty. And there are some funny consequences that also ensued from the exceptions and the exemptions that Prohibition allowed, such as
No,
for religious use of
right,
wines and things that were considered intoxicating.
right. There's a delightful the story, it's maybe apocryphal, but when Harlan Fiske Stone joined the Supreme Court in 1925, he could not legally move his extensive wine cellar from New York City to Washington. And his sons, who were 21 and 22 years old at the time, and had encouraged him to move it with him, take it with him, but he refused, stating that he was not going to begin his tenure at the Supreme Court by breaking the law. And so the collection remained in New York, reportedly to the great joy of his sons who remained there. But
Yes, I
are
imagine.
there, I'm sorry.
Yeah, yes, I imagine. Yes.
Are there other stories from Prohibition and about the justices, and we can talk further back as well?
Well, since you mentioned Stone, I will just say that his papers, which are in the Library of Congress, are full of just wonderful elements of his own enjoyment of particularly wine, and also his interest in his wine collection, and different aspects of his appreciative nature of
Mm,
the recreational use of alcohol. But another interesting story, perhaps, that I don't think it's apocryphal either. I think it's true. And this would be about William Howard Taft, who, as many of your viewers may know, served as both president and also Chief Justice. And most historians and commentators think he endured the presidency, but loved being on the court and loved being the Chief Justice. It was his life's ambition. And he did sort of orchestrate to get himself appointed, which finally did happen. But once it had happened, Prohibition had already come into effect. Fortunately, Taft learned of his appointment to the court when he was in Montreal and celebrated with a glass of champagne, which was, of course, legal in Montreal. And so that, I think, is an interesting little tidbit. Taft, of course, became a fervent defender of Prohibition once he joined the court as Chief Justice. He was a positivist and believed enacted law was valid. He never agreed with Prohibition and had vetoed earlier laws related to it.
mm.
But he did want to celebrate with a glass of champagne.
Great. And what about the stories of Chief Justice Marshall and his court and their fondness for Madeira?
Yes, well, the generation, the founding generation, and thereafter for the next couple of decades, we're great fans of Madeira, which is a fortified wine, and was quite popular as an imported product. And Chief Justice Marshall, I think, has the distinction of probably being the only leader of the court to hold conference in a boarding room, tavern rooms. In other words, in the public rooms of a boarding house where the justices lived together. And this was very common in early Washington. People that came to Washington did not move there permanently. They often lived in these boarding houses together. And the court had no home at that point. It only had a room that it convened in the Congress. And so conferences were held at the boarding house, over the boarding house table, usually accompanied by what would have been typical with meals, drinking of light wines like Madeira, and sometimes also a period favorite rum punch.
Mm.
And Marshall himself was a member of a club, a Richmond club, that had its own particular recipe for a particular rum punch that he was very fond of. So, Marshall was quite an imbiber, as were most people of the time, of that period of our history.
Yes. Yeah. What inspired you to begin writing about the court and its in this jurisprudence? You mentioned some events earlier that led you to Tulane.
Oh my. Well, I've always been interested in political philosophy, I guess.
Mhm.
My broad answer, and the theory of democracy, and the importance of the rule of law and constitutional governance. And I suppose my studies, which originally were in the field of political philosophy, gravitated more and more to constitutional interpretation, and then ultimately to my political science career, which is to look at how the Supreme Court functions both as a legal actor and a political actor. And so that has led me to what's been a wonderful academic career, teaching and writing, and occasionally writing books like this one, Glass and Gavel.
Well, you picked a wonderful place to do it, and New Orleans is a great city. Um, we were all saddened by the loss of Justice O'Connor on Friday. She and her husband John were very warm and gracious hosts. They became well known, certainly in the area here, for that. Can you share some stories about them as hosts?
Well, I did find a very interesting artifact in the Blackman papers when I was actually doing research that was unrelated to Glass and Gavel. I found a Blackman, as many of you know, saved everything.
Hmm.
So the Blackman papers are boxes and boxes of things, and some of them might be considered ephemera, right? They're not legally important materials. They're things that Blackman saved. And here we are. And among the things he saved was an invitation, a party invitation, from Sandra Day O'Connor on behalf of she and her husband to a party at their house that had a Western theme. And of course, she was a native Arizonan and was very proud of it. And so this party, I think, is quite interesting because, as you can see, pleasure of your company for fajitas and frivolity. And it's from 1992. She indicates dress should be country Western or effete Eastern. And I think it just shows her sense of humor, her sense of playfulness. But the reason I included it in Glass and Gavel is I think it marks the presence of what is a very important cocktail from the 1980s through the 1990s that I'm sure everyone has heard of and had, and that's the margarita. And so when I think of a fajitas and frivolity party, I'm sure the frivolity was probably provided by the company, no doubt, but also by serving margaritas. And I think this, I don't have corroboration of this with photographic evidence, but I can be pretty sure that this is an occasion that probably included serving what is, to some cocktail scholars' minds, the most popular drink in the United States, the margarita. So that's my O'Connor tidbit. I understand you're also making the mocktail that is a tribute of a kind to O'Connor as well.
Well, that's yes. As I mentioned, I poured myself a mocktail of what's called the Arnold Palmer. It's iced tea and lemonade. Doesn't quite measure up to a margarita, but appropriate. I'm still at the office, and Justice O'Connor was a great golfer.
Mm-hmm.
And so there is that connection with the Arnold Palmer. Just O'Connor she really worked hard on her golf game and wouldn't play competitively or with others until she really felt as though it was a presentable game. I know she spent a lot of time, a couple of years, I think. I've had a discussion with her once about it and how she went about training herself to play golf before she ever would play with anyone else, either competitively or for fun. But that's the way she devoted herself to almost everything she did was, all in.
Yes, indeed. So it's appropriate you're having the Arnold Palmer.
Yes, yeah, exactly. Well, we have some questions from the audience I'd like to share with you that have been sent in, or if you have any other anecdotes you'd like to share with us, Nancy,
Oh,
please do.
there are many anecdotes possible to share, but perhaps we should turn to some of these patient questioners
Sure.
to see and I'll do my best with fielding them off the cuff here.
All right. Al Capone is the most famous gangster during Prohibition. Do we know if he had a favorite cocktail?
Oh, if he had a favorite cocktail. Well, I cannot speak to that, although the time period that Al Capone was drinking would have included a lot of gin-based cocktails, a lot of bootleg gin, which sometimes wasn't the greatest gin, and so needed to be disguised with other ingredients. And so we see the rise of a lot of orange juice being used in gin-based drinks to try to cover up some pretty horrible liquors. That's the best I can come up with on Al Capone. Al Capone has kind of an interesting intersection with Chief Justice Hughes, though, because a case involving Al Capone and his evading of paying income taxes or paying taxes did come to the court under Hughes. And there's a very famous, I wish I'd included this image for you to see. There's a very famous Vanity Fair cover done by a cartoonist at the time, showing the two men looking at each other across bars. Obviously, Al Capone is behind the bars. And it was a wonderful caricature of their two faces. And Hughes saved it. He tore a copy of it off, a copy of the magazine, and it was found in his papers. And I remember seeing it many years ago now at an exhibit that the Supreme Court had in its own building, and it was quite interesting. A little sliver of, again, popular culture of alcohol and the law.
Yes, yeah.
Oh, good, you found it. Yeah, there it is. There it is. And Chief Justice Hughes was often thought to be the quintessential image of what a Chief Justice should look like.
Yeah.
William Douglas, I think it was, said he looked like God.
Yeah, that's a great image there. Another question. After the repeal of the 18th Amendment, what happened to the temperance movement?
Well, I think the temperance movement has never really died. The impetus about moderation and the moderate approach to alcohol, I think you see emerging or re-emerging perhaps by the 1970s. Now, we don't think of the 1970s normally as a period of moderation, but I think what begins to be a question both in the law and in society once alcohol is legal again is are there concerns with abuse of alcohol that go beyond moral judgment, that address questions of medical concern, or
Mhm.
a medicinal approach to thinking about abuse of alcohol? And so we get some cases about that, and I think we start to get a social conversation about that that also is entwined with another public policy problem, which is drunk driving.
Mhm. Mhm.
So the attitudes about drunkenness, including fairly excessive use of alcohol by some former members of the court during the 1950s and 1960s, say, I think those attitudes begin to change. And you could argue that this, in a way, is a continuation of the conversation about temperance and what temperance means. And so even in our era, and perhaps the example of our mocktail shows that, we are again having a conversation about how much use of recreational alcohol is appropriate. Um,
Mhm.
is there a
Mhm.
downside to the culture around beverage alcohol and inebriation?
Right, right. Looking at more recent Chief Justices, Chief Justice Warren Burger was known for his tastes in wine, and he belonged to some fairly sophisticated wine tasting groups. Do you have any stories about him, Chief Justice Burger, and wine?
Oh, yes, and I think we have another image coming up.
Yeah.
Um, uh, Warren Burger there is pictured on the far left. Warren
Hmm.
Burger was a great fan of German wines,
Mm.
particularly German white wines. And I know from talking to one of his former clerks that he was very pleased, to serve these wines, to enjoy these wines. This is a image that a cartoonist who did a lot of work for the Supreme Court made of a dinner. Turns out it's a Supreme Court Historical Society dinner, of
Hmm.
which Berger was a great patron. And it's interesting. It's showing a very convivial gathering, wine glasses on the table. Um, and Warren Burger, like Harlan Fiske Stone, had his own wine cellar that he kept at the court. And reportedly, it had quite a lot of nice bottles of, again, German white wine, which was just becoming popular in a mass market in the 1970s. And really, I think the quality level of German wines that many of us would now enjoy were just coming into fashion. And so he was kind of on the cutting edge of that.
Well, I'm glad to hear that. I worked in his chambers when I first came to Washington in 1975, and he gave me as a Christmas gift one year a bottle of German, white German wine. So now I have all the more appreciation for it as you've described it, how special that was. Um, but yes, that was those were he was an expert, I think, in it, or learned much about it. We have another question coming in. It's of all the eras of Supreme Court history, what was your favorite to research?
Oh boy, that's a that's a tough one. Golly. Well, hmm, hmm. I must say the era of Chief Justice Marshall seemed like the most fun to be part
Mm-hmm.
of. And I thought it was the most interesting to examine because it was sort of the foundational period for the court and
Mm-hmm.
the foundational period for the relationship between the Constitution and alcohol. And it was also an era, a political era, in which alcohol was very much a part of public life. not in a way that it was abused, but in a way that it was integrated and appreciated. And, Marshall was, of course, famous for being a very powerful court leader that drove his court to unanimity. And it was the power of his personality, many described, that aided that project. And that really strengthened the court as an institution. And one wonders if he was aided in that project by the fact that he and his colleagues sat around a boarding house table and lubricated their conversations and maybe their difficulties. I also think our current era is a fascinating one to look at how the more modern uses and enjoyment of alcohol play out against some of more recent decision making and recent questions about how we should calibrate both regulating and restricting alcohol, but also creating a regime for its enjoyment. And so, if white wine was Warren Berger's favorite beverage, I would say the era that begins with our current Chief Justice is one in which we see a lot of evidence of red wine and red wine fans having served on the court and famous incidents involving red wine. The late Justice Scalia, for example, was a great aficionado of Italian reds and often enjoyed a glass with his favorite anchovy pizza that he would have with his clerks for lunch. And so wine, I think, has moved in modern American consumption to be even more prevalent than cocktails. We're not as, although there's been a great, resuscitation of classic cocktails and revivals of, classic looking cocktail bars, we are simply not as heavy drinkers as people in the United States were, let's say, in the 1940s or 1950s or 1960s. We are wine drinkers much more as a culture. And I think the current period has a lot of interesting, very interesting law in it as well.
Well, you've picked some very interesting topics to cover in your career, and it's been a delight to speak with you this evening about them. We're also happy to note that copies of your book, Gavel and Glass, are available on our gift shop at www.supremecourtgifts.org. And we know that we want our members who are participating tonight, we're delighted to be able to reach out to them with programs such as these. It's one of these, the upshots of the pandemic is that we've done more and more of these kinds of programs, and we're going to continue those. And Nancy, we're very grateful to you this evening for early evening for joining us. And we will send around a survey to go out later tonight to everyone who registered for the program in advance. And we hope you'll respond to it. We want to make these programs as informative and accessible to as many people as possible. We're going to not only resume in-person programming here in Washington and at the court, but we're going to continue these virtual programs as well. And Nancy Maveety, we're delighted you were able to join us this evening and enlighten us about your work and these topics. And it's been fun. It's been an interesting dive into the 18th Amendment and its repeal and the history behind it.
Well, thank you so much for having me. It's been a real pleasure, and I think this is the ideal setting for a virtual program, isn't it? Because people at home can be doing what they like.
Exactly right. Well, we hope to see you in Washington whenever you're in town. I hope you will stop by. And thank you again for your presentation tonight.